Hello everyone and welcome to the channel Ontario Law and the Older Person. And in this video we're going to talk about consent and healthcare, as in the need to get consent, who can give consent, and it is going to be a dry video. We are going to be looking rather painfully closely to certain sections of a statute. And I won't be addressing ageism in this video because we're just going to have to focus on what is consent, what it means, things like that. I'm going to be getting into ageism when we talk about capacity in a different video, whether someone is determined to be capable of giving consent. But this is just what are the elements of consent, when is it necessary, and I will be touching on a court case at the end. The information provided in this video is not legal advice. It is relayed for the purposes of general information. No legal decisions should be made based on this material. Any viewer who needs legal advice should contact a lawyer. We are going to spend a boring amount of time talking about this statute, just a little part of this statute. It's huge. It's called the Healthcare Consent Act, 1996. You can find it on CanLII or eLaws. We're going to start with Section 10, subsection 1. A health practitioner who proposes a treatment for a person shall not administer the treatment and shall take reasonable steps to ensure that it is not administered unless A, he or she is of the opinion that the person, as in the patient, is capable with respect to the treatment and the person has given consent, or B, he or she is of the opinion that the person is incapable with respect to the treatment and the person's substitute decision maker has given consent on the person's behalf in accordance with this act. So the thing to keep in mind here is that it's a human being, either the patient or their substitute decision maker, who gives or withholds consent. The healthcare provider can't just refer to a document. Now, when it comes to DNRs, it gets more complicated, so I'm not going to talk about it. I'm just presenting this as the general rule is it has to come from a person, not a piece of paper. The elements of consent. Section 11, subsection 1. The following are the elements required for consent to treatment. 1. The consent must relate to the treatment. 2. The consent must be informed. 3. The consent must be given voluntarily. 4. The consent must not be obtained through misrepresentation or fraud. Informed consent, and this is going to be the subject of the court decision I'm going to talk about at the end of the video. So this is 11 subsection 2. A consent to treatment is informed if before giving it, A, the person received the information about the matters set out in subsection 3 that a reasonable person in the same circumstances would require in order to make a decision about the treatment, and B, the person received responses to his or her requests for additional information about those matters. Subsection 3. The matters referred to in subsection 2 are 1. The nature of the treatment. 2. The expected benefits of the treatment. 3. The material risks of the treatment. 4. The material side effects of the treatment. 5. Alternative courses of action. 6. The likely consequences of not having the treatment. And I got to tell you, just as an individual, with my issues with healthcare, there were so many times where I was not given anything about the risks of taking this particular medication or the side effects or anything like that. I had to get that information from other sources, which I think is problematic. Subsection 4, consent to treatment may be express or implied. And wow, implied, that's a very difficult area. How do we know whether someone has actually implied something or not? It can be very context heavy. It can depend on culture. It can have some pretty problematic outcomes. Anyway, 12. Unless it is not reasonable to do so in the circumstances, a health practitioner is entitled to presume that consent to a treatment includes A. Consent to variations or adjustments in the treatment if the nature, expected benefits, material risks, and material side effects of the changed treatment are not significantly different from the nature, expected benefits, material risks, and material side effects of the original treatment, and B. Consent to the continuation of the same treatment in a different setting if there is no significant change in the expected benefits, material risks, or material side effects of the treatment as a result of the change in the setting in which it is administered. Section 14. A consent that has been given by or on behalf of the person for whom the treatment was proposed may be withdrawn at any time. A, by the person, if the person is capable with respect to the treatment at the time of the withdrawal. B, by the person's substitute decision maker, if the person is incapable with respect to the treatment at the time of the withdrawal. And now I'm going to talk about something that might be triggering to people. So warning, 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 warning. Okay, while I am usually a supporter of medical assistance in dying, there's a terrible situation that has arisen where someone sought MAID, but then withdrew their consent, and that they rushed another assessor to come on board, and basically she was given MAID even though it seems clear that consent was withdrawn. And I think there should be some serious criminal consequences for the healthcare providers who let this happen. Anyway, you're supposed to be able to withdraw consent at any time. I am now referring to the website Advanced Care Planning Ontario. It gives a bit of a description that I like for one of the issues that are relevant in these circumstances. They actually give a lot of information. It's kind of rephrasing what the statutes say. And don't treat this information as legal advice. It's just general information. The link to the website is in the description. I'm referring to their definition of plan of treatment because that's a concept that shows up again and again. So directly from their site, a plan of treatment means a plan for care of a patient that is developed by one or more health practitioners, deals with one or more of the health problems that a patient has, and may, in addition, deal with one or more of the health problems that the patient is likely to have in the future, given the patient's current health condition, and provides for the administration to the patient of various treatments or courses of treatment, and may, in addition, provide for the withholding or withdrawal of treatment in light of the patient's current health condition. So basically the idea that treatment isn't just like a one thing and go, it can be more long term. If a plan of treatment is to be proposed for a patient, one health practitioner may, on behalf of all the health practitioners involved in the plan of treatment, propose the plan of treatment, determine the person's capacity with respect to the treatments referred to in the plan of treatment, and obtain a consent or refusal of consent from the patient for those treatments in the plan that the patient is capable to consent to, and from the patient's substitute decision maker for the treatments in which the patient is incapable. And this last bit is an introduction to something that I will elaborate on more in my video about capacity. And that's the idea that capacity isn't the same across the board. A person might have the ability to make decisions in one area, but not in another. So that's what they're saying here is when the patient can make a good decision, their decision is where you go with, what you go with. If they can't, then that's when a substitute decision maker might have to step in. This is a court case I'm going to discuss for a few slides here. Denman versus, or and, as we put it. Yes, I'm going to butcher this name. Radovanovic. It is a 2024 case of Ontario from the Court of Appeal. So what happened is Denman brought a trial against Radovanovic, and I'm just going to call him R from now on. And Denman won. R was upset about that. So this is the appeal decision. So R brought it to the higher level of court, trying to get the first decision thrown out. And the spoiler alert, he doesn't succeed. So this is the quote from paragraph 1 of the court decision. The central issues underlying this appeal are the nature and extent of a physician's duty to obtain informed consent for a multi-step course of elective medical treatment, and on which physicians involved in treatment does this duty rest. Now you might notice that the paragraph numbers, so those are the numbers at the very top left there, they're going to be out of order, and that's because, as I've mentioned in other videos, I find the way a lot of judges write their decisions kind of illogical, and they jump all over the place with different issues. So I'm trying to put the paragraphs in what I consider a logical order. So 44. The issue in this appeal is not whether consent was given to the various procedures Mr. Denman underwent. In each case, consent was obtained from Mr. Denman. Had consent not been obtained, clearly the physician who carried out the procedure would be liable in battery. Rather, the issue is whether the consent that Mr. Denman gave was an informed consent. Paragraph 47. A patient alleging lack of informed consent must not only prove that the information provided was inadequate, but must also establish causation. Specifically, the patient must prove that 1. They would not have undergone the procedure had they been adequately informed, and 2. A reasonable person in the patient's position would not have undergone the procedure if given adequate information. Then they list a couple of other court decisions. Last sentence. In other words, in assessing causation, there is a subjective, that's the person making the decision, and modified objective test. And the modified objective test is, what would the reasonable person do? So we're going up to paragraph 2, and I'm going to define some vocabulary here. So in 2015, the respondent, Michael Denman. Okay, so Mr. Denman was the patient. He started the lawsuit originally suing the doctors. So in that trial level, he would have been the applicant and the doctors would have been the respondents. Now, this is an appeal. The doctors brought the appeal. So the doctors are referred to as the appellants. Now, in this level, Denman is the respondent. So when I say respondent, that means Denman, the patient. When I say appellants, that means the doctors. Okay, so in 2015, the respondent, Michael Denman, suffered a catastrophic brain bleed as a result of a medical procedure aimed at curing an anterior ventricle malformation, AVM, in his brain. There is no suggestion that the procedure, which was part of a multi-step treatment plan, was performed in a negligent manner. Rather, the respondents brought a claim alleging the appellants, 3 doctors at the Toronto Western Hospital, had failed to obtain Mr. Denman's informed consent. The respondents sued in negligence, alleging that if the appellants had not breached their duty of disclosure, neither Mr. Denman nor a reasonable person in his circumstances would have proceeded with the recommended elective treatment plan. Paragraph 3. And no, I'm not going to be going through the entire case. It's a long one. I'm just picking up some of the bones to try to explain bits of what you just learned about the statute. So, paragraph 3. The parties agreed on damages of 8.5 million, except weirdly later the doctors fight against that, but whatever, that's what it says. The sole issue at trial was whether the appellants, the doctors, were liable based on a failure to obtain informed consent. Following a 26-day trial, which is long, the trial judge held that all 3 appellants were liable. In reaching that conclusion, she stated, so this is a quote from that trial, "Had appropriate disclosure been made, neither Mr. Denman nor a reasonable patient in his circumstances would have elected to proceed with any of the medical interventions recommended by the appellants at the time the recommendations were made. I agree that any decision to treat or not to treat would have been deferred by Mr. Denman until after his retirement, so he could have amassed savings with the full support of his family and his employer. So he would have made different choices." Paragraph 26, which is definitely going to be a challenge for me. I'm stumbling over a lot of wording here. Sorry about that. Okay, so one of the doctors involved met with Mr. Denman on June 5th, 2014. At the meeting, the doctor discussed the risks of a single embolization procedure, which was the first step in the plan of treatment for Mr. Denman's AVM. The doctor testified that he told Mr. Denman that the embolization carried a 3 to 5% risk of stroke or death. Mr. Denman was directed to a TWH website that reported that a single embolization treatment carried a small chance of stroke, about 1 to 3%. Paragraph 27. Notably, the doctor did not discuss the possibility that further treatment would likely be required. So, stepping out of the court decision for a bit, Mr. Denman, when he was giving his consent to that first treatment, was not aware that it might not be the only treatment necessary in the plan. Okay, going back to the case, nor did he provide Mr. Denman with an estimate of his lifetime risk should he forego treatment. So when we're talking about capacity, if someone is denying treatment, do they understand the nature of the outcome if he denies or she denies? Yes, then we go with that decision. So whether they understand the risks of not making a decision is of determining whether someone has capacity to make choices. Paragraph 76, as I skip some stuff. As highlighted by the trial judge, the appellant's own expert, Dr. Roy, testified that it would be absurd and misleading to tell the Denmans that there was anything less than a 10 to 15% risk of significant morbidity or mortality for the combined procedure. The trial judge accepted this evidence. Paragraph 101. The trial judge also explained that the doctor's inadequate disclosure of risk was made worse by him directing Mr. Denman to a misleading website that understated the risk of adverse outcome for even a single embolization. Who does that? I mean, I think that's a terrible idea. The expert, you're supposed to get information from the expert, and they said, Google it or something. Yikes. Paragraph 39. At the conclusion of the trial judge granted judgment against all three appellant doctors. She reached the following key conclusions. So this is text taken from that other judge's decision. 1. All three of the appellants failed to obtain Mr. Denman's informed consent to a multi-step course of elective medical intervention. So when they started, they weren't telling him there's more to come. Didn't get his conformed consent. And then 2, had appropriate disclosure been made, neither Mr. Denman nor a reasonable patient in his circumstances would have elected to proceed with the proposed plan of treatment. So that was proving causation, right? He wouldn't have done it, and a reasonable person wouldn't have done it. That's the 2 requirements to prove causation, and he did. 3. The risk assessments provided to Mr. Denman by Dr. Pereira and Dr. Radovanovic prior to the June 23, 2015, third embolization and planned microsurgical resection of the AVM were grossly misleading and deficient, and that had appropriate disclosure been made, neither Mr. Denman nor a reasonable patient in his circumstances would have elected to proceed with the June 23rd and 24, 2015 combined procedure. 4. Had appropriate disclosure been made, Mr. Denman would have deferred his decision on treatment until after his retirement with the full support of his family and his employer, so that he could continue to earn significant income to support his family. So the end result was the Court of Appeal approved what the original trial decision was, that these guys are on the hook and they should be paying for this. Okay, now, last slide, I'm going to describe the results of their surgery. It's a little grim, so you might want to stop here. Paragraph 37. As a result of the brain bleed, Mr. Denman was left densely hemiplegic, one-sided paralysis, on his left side, fully dependent for all care and only able to communicate by writing and gesturing. So sure, he gets millions of dollars, but I'm sure he'd rather this whole thing didn't happen at all. So pretty grim possibilities when a patient isn't properly informed. Anyway, so I know that's a bit of a grim one. If you got to the end, I'm glad you got to the end. If you find this information useful to you, it'd be great if you subscribed and liked, and have a great afternoon.